Good day. I am Barrister Mrs. Ijoma Maxiri Lanosi. I'm the principal partner at ICNC Legal Practitioners, which is a leading law firm based in Lagos, Nigeria. And this is the ICNC Law Lecture Series. Today we'll be discussing a topic on the family law, one which is very sensitive, one which has trended in recent times. Today we'll be discussing DNA testing as an offshoot of suspected adultery in married couples. The Matrimonial Causes Act is the principal legislation that regulates the divorce of monogamous marriages in Nigeria. So what that means is, if your marriage was contracted under Islamic law, or if it was contracted under customary law, which is naturally polygamous in nature, then the Matrimonial Causes Act would not be applicable to you. However, if after contracting your marriage under Islamic or customary law, you still went ahead to do what we generally term as a court marriage, then the marriage can be said to be monogamous. The Matrimonial Causes Act provides for just one ground upon which a person can file for a divorce in Nigeria, and that ground is that the marriage has broken down irretrievably. For you to say that the marriage has broken down irretrievably is for you to say that the marriage can no longer be repaired. The law provides for 8 instances in which the marriage would be said to have broken down irretrievably. However, because of the length of this video and because we wouldn't like to spend too much time, we would be addressing just one of those 8 grounds today, and that is adultery as a ground for divorce. The Matrimonial Causes Act provides that one of the grounds for dissolution of marriage is that adultery has been committed and that the petitioner finds it intolerable to live with it. So that gives you 2 legs of the ground of under adultery. First, you have to prove adultery. Second, you have to prove that you find it intolerable to live with your spouse who has committed the adultery. It is necessary for us to state at this point that matrimonial causes or family law in general is highly discretionary, and that is why you hear us using a lot of may or should, or using a lot of words which mean probability. That is not to say that we are unsure of what we are saying. That is just to say that family law is highly discretionary, and so what one judge would do is not what another judge might do, and we're going to do a separate video addressing what discretionary justice means with regards to family law. Now back to adultery as a ground for divorce. The court has held in a certain case that where a partner goes ahead and has sexual intercourse with their spouse after adultery has been committed by that spouse shows that that partner does not find it intolerable to live with that spouse. And so in that particular case, the court did not grant the dissolution of marriage based on adultery. Secondly, adultery can only be alleged where the sexual intercourse was not only voluntary but was consensual between both parties, which means if your spouse was raped, if your spouse was drugged, if your spouse was intoxicated by alcohol, if your spouse was insane at the time of commission of the alleged adultery or sexual intercourse, then that's not adultery under the law. For you to allege adultery, the sexual intercourse must not only be voluntary but must also be consensual, which means that if your spouse was under any form of undue influence or duress, then that's not adultery under the law. Also, for you to allege adultery, there must be penetration. The law does not specifically say whether it should be complete or incomplete, but under criminal law, once the labia minora of the woman, that's the sexual organ of the woman, has been touched by the sexual organ of the man, it suffices as rape even if there is no penetration. So that's a stricter proof under criminal law. However, under family law, penetration suffices as adultery. So it's not a must to say, oh, there was no ejaculation, or to say, oh, birth control was used, because I've heard a lot of people say, oh, birth control was used and all of that. It still suffices as adultery. Next is the fact that the law recognizes that adultery is something that is difficult to prove, and that's because people don't walk around with cameras, so there is really hardly documentary evidence to tender as proof for adultery. And so the law allows for circumstantial evidence, which we can define as indirect evidence. And that's why in the case of Akinremi and Akinremi, the court, I beg your pardon, ruled that adultery was indeed committed, where a man walked in on his wife in the dark with another man. Both of them were in the bedroom, and the wife was tying a wrapper on her chest, sitting on the edge of the bed, while the man had his trouser partly untucked, and the court ruled that that can be inferred to be adultery. However, because, like I said before, family law is highly discretionary, and so what one judge would do is not what the other judge would do. And that's why you find in the case of Erahon and Erahon, please pardon my pronunciation, the court said that adultery was not committed, where a man tendered 9 pictures showing his wife in compromising positions with another man. Some she was lying on his lap, some she was half naked, and all of that. But the court still held that that's not a proof for adultery, because that does not show that sexual intercourse actually occurred. However, there are instances in which adultery will be most likely presumed or highly presumed, except there's a contrary evidence to that effect. First is where parties are cohabiting, where the parties to the adultery are cohabiting. Of course, where a married man or a married woman moves into another apartment and begins to cohabit with another man or another woman, that can lead to a presumption of adultery. Second is where there's bigamy. Third is where the partner frequently visits brothels. So where you can provide evidence that your partner frequently visits brothels, it can lead to a presumption of adultery. Fourth is where a DNA test or a blood test shows that one of the children or child of the marriage is not that of the partner. Fourth is where there is documentary evidence proving that indeed adultery has been committed, such as where a birth certificate or any other document contains another name as the father of the child other than, or the mother of the child, other than the person who is supposed to be the mother. Also, where one of the partners confesses to the adultery, then that's complete proof as well. But then again, the court is always reluctant to accept an admission from a partner as a confession. The court is always very cautious, because sometimes you find that people just confess to committing the adultery just to get away from the marriage, not necessarily because they actually committed the adultery in fact. Lastly is where there is the contact of a venereal disease. So where one of the parties has contacted a venereal disease, which he can prove, please mark my words, which he can prove to have contacted from his spouse, then that's a complete proof of adultery. So if, for instance, your spouse works in a hospital, maybe as a doctor or a nurse or one of the other staff of the hospital, and comes in contact with a patient who has a venereal disease and therefore contacts it from that patient, you cannot conclusively say that your spouse has committed adultery simply because he or she has that particular sickness. You need to also go ahead to prove that that venereal disease was contacted to sexual intercourse from another person other than you. And that is basic information about adultery as a ground for divorce in Nigeria.